First up was Brian Albert, and this was for cross-examination. But before the witness even took the stand, they had to have a sidebar because the prosecution was objecting to something that the defense wanted to use in cross. So they did that. Brian Albert was attired in a similar fashion as he was on Friday, and somebody had pointed out in the comments that he wore a Mr. Rogers sweater. And before he took the stand on Friday, I was interested in how he would dress, given that he is an experienced officer with lots of experience on the stand. I wondered if he would dress like a detective or if he would do something different, and he kind of did a combination. So he's wearing the tie with the collar and everything and the Mr. Rogers sweater. So that was interesting. I think that's intentional. The defense brought out that Brian Albert, given his experience, is accustomed to testifying. He's an experienced witness. The defense asked if the witness had spoken to the prosecution since April 2022. And the answer was that he does not recall speaking with Lally since that time. Now, I'm going to point out some language here. He's saying he doesn't recall speaking with him. The message he's giving is the answer is no, and the hedge is I don't recall. So sometimes people say this because they're not sure, and that's the truth. They're not sure. And sometimes they say it because they're hedging, and so you want to look for a pattern, right? So just stick a pin in this. The defense asked him, did Lally or the prosecution go over questions you might be asked? Brian Albert says no, and Brian Albert did say he was shown a clip of a video from the waterfall. So this is interesting to me, not because there's anything terribly wrong with it, because sometimes a prosecutor or a defense lawyer, or any lawyer for that matter, will show a witness something and ask a question about that. Like, I'm going to show you this clip of this video, like, what were you doing there? That sort of thing. The reason, though, that this is important, the fact that he's seen this, is because having seen that video, he knows now that there is video from inside the waterfall, and so he can't lie about Karen Reed's behavior or her state. So if they want to sort of set her up and really frame her, if that's the thing, you'd expect them to say, oh yeah, she was falling down drunk, or she was yelling, or whatever. But now the witness knows there's actual video, and they're not going to get away with saying anything that could be contradicted by that video that he's just seen. Then it turns out, well, what Brian Albert just said about not speaking to Lally since April 2022, well, that was wrong. It comes out that actually, yeah, he and the prosecution did prep for this trial not that long ago. As this came out, you could see the witness's mouth just go dry. Further, in that prep, Brian Albert was able to review his grand jury testimony. There's nothing wrong with that. The problem is lying about it. Don't know why you'd want to lie about that, but okay. And they talked about the 20 seconds of video that he saw from inside the waterfall. And interestingly, he phrases it as him and Brian Higgins fooling around at the waterfall. So do you remember that video clip of where they were in what looked like a fighting stance and they were play fighting? He's saying this is fooling around. And that term, or avoiding the term of play fighting, seems very important to him. Also, recall his wife's testimony and how she seemed to take exception to the phrase play fighting. And she wanted the narrative to be fooling around. It seemed very important to her. So obviously, this is significant to both Brian Albert and Nicole Albert. The defense and the witness go back and forth, and this witness does not want this interaction with Brian Higgins to look at all like play fighting. And he says he doesn't remember any fighting poses. The defense was saying, well, were you showing him how to throw a punch or how to get down really low? And now the witness doesn't recall that. The defense asked, did Lally tell you what you could be asked? And the answer was yes. So before he didn't even speak to Lally and wasn't prepped, and then he was, and so this is all changed. So he's obviously impeached. And I just want to say something about witness prep. And I know people do it differently. Normally, when they prep you, they don't give you specific questions. I'm going to ask you this and this is your answer. You can't do that. They will often say, these are the kind of areas, the subject matter that might be covered. But to cover your butt, if you're doing witness prep with a witness, it's better to actually be even more vague. So I will say to witnesses things like, tell the truth to the best of your recollection and ability. If you don't remember, don't make something up. Don't fill in blanks. If you don't know, you don't know. If you're asked about something and the truth is embarrassing, tell the truth anyway. Go ahead and be embarrassed, because it's better than perjuring yourself or messing up something that you know nothing about. Just tell the truth. And you don't get into anything overly specific. So I still don't know how specific Lally would have got with this prep and telling the witness, these are things you might be asked, because that's a little too specific. Then the defense asked, do you want to change any of your earlier testimony, including your testimony to the grand jury? The witness says no, but he's already been set up. You see, they went through this whole thing. You know you're under oath. You know you were under oath times you testified before. You're an experienced witness. You know how important it is. You were a police officer, so you know how important it is to be accurate, right? So if he suddenly wants to change his testimony, he's going to have to come up with an excuse for that, because then they can say, well, were you lying then or were you lying now? That's a favorite of lawyers. So he says he doesn't want to change any of his testimony. And just as a side note here, if you're ever in a position where you testified to something and then you remember later, oh my gosh, I was wrong, it's better just to admit that. It's better just to come out with that. All right, back to this. The defense asked, did you watch any media coverage of this? The answer was no. Did you discuss the case and what was going on in court, right? These proceedings, did you discuss that with your wife? And he says no, which I find odd. But again, if you're an experienced police officer, or if you've worked in the criminal justice system for a long time, you may well say to your family, hey, it's better if we don't talk about this until everybody's testified. And that's another thing I say to witnesses. Look, if your friends are witnesses, you guys got to come to an agreement. You're not going to talk about it. It's just better that way. There's a whole minefield that you avoid by just not talking about it. So maybe he's like that. But if he was like that, he wouldn't have sat and talked to Sergeant Lank at a table full of people. And he wouldn't have run over to Jen McCabe's house as soon as he heard a trooper was coming. On we go. He was asked if he was close friends with Brian Higgins, and he says no. And I almost started laughing at that. Why, if he's not close with Brian Higgins? Is Brian Higgins the only non-family member at the Albert home the morning after when there's a tragedy and people are upset? If you are so upset about your fellow officer or your acquaintance or friend being found dead on your front lawn, and Jen McCabe is, according to them, hysterical, contradictory to what you heard in the 911 call, contradictory to what you saw on dash cam, but okay. If she's so distraught and this family is going through this terrible thing, you don't want people you don't know that well being with you, do you? If you're going to have someone over who's not family, wouldn't it be the closest of your friends? Would you call up a casual friend and say, come over, we're having an emotional time, come and be with us? No. The defense brought out the fact that Higgins and Albert drove from New York to Boston together. That trip was approximately 4 hours. And even after that, they stopped and had a drink at the hillside. They've known each other for 15 years, but the way Albert says it is, well, we met 15 years ago at work. The defense asked if Brian Albert and Brian Higgins discussed Karen Reed at all when they stopped at the hillside or during that 4-hour drive to Boston, and he says no. The defense asks, well, didn't he tell you about how he was flirting with Karen Reed only 2 weeks ago? The witness says no, he never said that. Here's the thing. If this is true about Brian Higgins, if Brian Higgins was flirting or interested in Karen Reed, we have motive. The problem is that the motive is not the motive of the person who is on trial. The defense asked, did Brian Higgins say anything when you were at the waterfall about Karen Reed and John O'Keefe when they came in? The witness says no. Did he say anything about them being together? No. He didn't know John O'Keefe, but he seemed like a nice guy. And he agreed that he was better friends with Brian Higgins than he was with John O'Keefe. Then the defense brings out grand jury testimony, except this is a different grand jury. This was not the Commonwealth grand jury. This one was June of 2023. So a non-Commonwealth grand jury. So Lolly wasn't there. This defense team wasn't there. And Brian Albert testified there. And he testified that he believed Karen and John were at the hillside, but he can't say for sure. And this is consistent with his other testimony in this trial, where he said, yeah, he saw them at the hillside, and it sounded like they just kind of were there, like he noticed them. And then he testified at the April 2022 grand jury that was the state grand jury, 3 months after the crime. So before the 2023 grand jury, Brian Albert said he never met or saw Karen Reed before. But here's the thing, and this was a little bit unfair, because what it appears he did in this grand jury testimony was that he said he never met or saw her before, well, maybe once. So when the defense is coming after him today, they just focused on the never met her or saw her before. The witness kept pointing out that the defense was taking the statement out of context, saying, you only took half my statement. And this is a trick that lawyers use. You said these words and they take something out of context, or they don't include the entire sentence, that sort of thing. And sometimes it's effective and important, and sometimes the rest of the sentence does change how it should be interpreted. But this witness, being an experienced witness, knows that lawyers do this. So he would know to say, you took this out of context. So this went back and forth and back and forth. Well, then it comes out that Brian Albert spent several hours with Karen Reed and John O'Keefe 6 days earlier at the hillside. And he ended up admitting that he was there with somebody named Tim Daly, Julie Albert, Chris Albert, Matt and Jen McCabe, and John and Karen. He was effectively impeached here. And he still tried to play it down. And he continues to play it down. Like he didn't really interact with her. He just saw her. Well, the defense produces a photo of them at the hillside 6 days prior to the January 29th. And the photo is of Chris Albert, Brian Albert, John O'Keefe, and Tim Daly having a good time, like arms around each other. And guess who took the picture? Karen Reed. Well, Brian Albert was sitting up on that witness stand pretending he had no idea who took that photo. And then he admits, well, he saw the photo in discovery, which means he has his own lawyer. Then he continues, in spite of this, continues to try and play it down. He doesn't remember actually speaking with Karen, but he had no choice but to agree that he was socializing with John. So you're out with a couple. Are you saying you're socializing with one half of the couple and not the other? He tried to make it sound like it was just John he was socializing, not Karen. And the defense brought out June 2023 grand jury testimony was that he didn't have any impression of Karen Reed because he only saw her across the table. Hello? That tells you they were sitting at the same table across from each other. Come on. And he wants people to believe, well, he just sort of saw her there like she was in the same building or something. They were sitting at the same flippin' table. In his previous testimony, he said he did not speak to Karen Reed at the waterfall. And this is the June 2023 grand jury testimony they're referring to here. Well, that's what he said, and then they pull out this video. And you can see in the video, he is obviously in conversation with Karen Reed specifically. This is not everybody talking at a table. This is him and her talking. It is so clear. Well, you know what his answer is to that? He says, well, I'm just talking at the table. And he kept trying to deny it. Then what he says when he's completely backed into a corner, he says, I do not recall conversations with her. I do not recall. And the judge pushes it along, like, let's move along. So the defense couldn't keep going. The defense brings out that Brian Albert had an interview with Trooper Proctor 6 days after socializing with Karen Reed, yet he said he did not know her. And the defense said, were you trying to distance yourself from Karen Reed? And he says, no. And the defense says, you knew there would be questions if it came out that you knew Karen Reed. And there was an objection. And they continued back and forth about the context or out of context of him saying he never met her or saw her before. The defense asked, did John O'Keefe come into your house? The witness says, absolutely not. The defense asked if there was any indication that Brian Higgins was upset about Karen and John being together. The answer was no. Of course, it's no. The defense asked, so John O'Keefe and Karen Reed seemed pleasant and happy? And the answer is yes. And I'm laughing. This actually goes to motive. Again, not for this defendant. I can't count how many times I've worked on a case involving somebody who was jealous, somebody who was told no, somebody who was not happy that the person they were interested in didn't reciprocate that interest. A guy unhappy about that, or a guy who's interested, not all of them, only certain personalities, would be triggered and angry by seeing the object of his affection happy with somebody else. The witness reiterated or confirmed that there was no indicia of drunkenness on Karen Reed's part, that both Karen Reed and John O'Keefe were acting appropriately. He had no choice but to confirm that he left the bar, Brian Albert left the bar at 11:58. And the invitation to come back to Fairview was to whoever wanted to come by was welcome to the house. He said on that day he started drinking at around 9-ish. So he's drinking at the hillside, didn't have anything to eat there, and was drinking straight through the night at Waterfall, but he felt okay to drive. He confirmed he had driven the Ford Edge to the Waterfall, and he drove the Ford Edge home after a night of drinking. He says when he got home, Brian Higgins was already in the driveway and was backing up. He said that to let Brian Higgins out of the driveway, because he was driving his white Jeep Wrangler, Brian Albert in his Ford Edge had his vehicle closest to the walkway on the left so that Brian Higgins could come out. He reiterates that he doesn't know where Brian Higgins actually parked. He agreed he would have gotten into the house at approximately 12:10. He said that Colin, Brian Jr., two of his friends, were at the table when he got in the house. Colin is 5'11" to 6 feet, was at that time, about 175 pounds, athletic, and a football player. So he's not a little guy. He said that he went to the bathroom, and when he got out of the bathroom, Colin was no longer there. He never saw Colin leave. He never saw a car outside waiting for Colin, and he never saw anybody pick him up. And I want to skip ahead a little bit. He's saying he went into the house and saw Colin at the kitchen table. Well, later on in his testimony, he says that he and his wife went in at the same time. So how is it then, if they go in at the same time, that she is literally bumping into Colin in the foyer, but he is seeing him sitting at the kitchen table? Which is it? They moved on to the conversation at 7 a.m. on the 29th, and the fact that Sergeant Lank was speaking to everybody at the same time. In Lank's report, he said that Brian Albert's daughter, Caitlin, left at 12:15. Well, the witness says, no, this is wrong. So here's the thing. The wife, Nicole, said the same thing as what this witness is saying. So either the report is wrong or the witnesses are. This is an example of why it is so important to have at least an audio recording of an interview, and video is even better. Sometimes you can't get video. Sometimes you just can't do it. But nowadays, everybody can do an audio. Neither the witness nor his wife mentioned to the police that Colin was there. And the defense brings out that Colin was not on the main floor, but nobody actually saw where he went. So there had this big back and forth about why Colin was left out, why Colin's name was never mentioned to any police. And you could understand, let's say Nicole or another civilian, not realizing that this is important. You could see somebody thinking, but he left, so I didn't think it mattered. You could see that. But as a police officer, Brian Albert knows better. We're not talking about some rookie here. He was a police officer for 30 years. He knows that that detail is important. If he was investigating a case, he would want that detail. You see, Colin leaving around the time that whatever happened, according to their timeline or what their theory is, well, he's a witness. You want to talk to everybody who was around, including immediately before and immediately after an event, because they could have seen not necessarily the crime, but they could have seen a car in the area. They could have seen somebody lurking in the area. They could have overheard something. There's 1,000,001 details that you just don't know that exist, that you don't even know yet, that you need. And that's why you interview everybody. And that's why you interview people that don't appear at first glance to a civilian to be involved in any way, because civilians see things and they have no idea of the significance of what they saw. Brian Albert knows that the fact that Colin was there in any proximity and time on that night matters, and he left that out. So you could excuse Nicole or some other civilian for not knowing better, but Brian Albert, an experienced police officer, knows better. The defense was asking him about this interview with Lank. So that first morning, the 29th, when Lank was doing like this mass interview with all the witnesses together at the table, and according to both Nicole and Brian Albert, it was chaotic. Brian Albert comes out and says, "I didn't consider that an interview." Oh, really? Would you consider that a coffee with your friend? Are you kidding me? It's an interview. Just because it's not in a police station, because it's not some big formal thing. It's an interview. And as a police officer, he knows that. He reiterated that Caitlin was the last to leave and it was 1:45 a.m. or after. The defense asked him on January 29th at 11 or 12, he had this interview with the trooper. And he says, were you notified that that interview was going to happen with Jen McCabe? And he says no. But on Friday, he had said that he did know that Jen was going to be interviewed. And that's why he went over there. So the defense says, well, you're a witness in this case, but you went over there. And he says he went over there. I mean, he can't deny that. Again, we are talking about an experienced police officer. He knows better. So why is he going over there if not to control in some fashion or keep an eye on things? It came out that Brian Albert was in Jen McCabe's house for the entirety of her interview. And you could argue, yeah, but they were in separate rooms eventually when it came time for the interview. But we don't know what the conversation was immediately before or after. And we don't know what he could overhear. Heck, at this point in this case, I think we don't know much of anything. Brian Albert testified that when they went to 34 Fairview on the night in question, that Brian Higgins walked into the house immediately after Brian Albert and Caitlin and Nicole. Then he was asked, did you ever go to the basement? And guess what his answer is? Oh, you expect a no, right? He says, I don't remember going to the basement. So we've seen a pattern with him that when he's not sure if he can get away with a thing, he says, I don't remember. I don't recall having a conversation with Karen Reed. Well, it's on video he did. I don't remember going to the basement. They got into the dog. The witness was a little more stoic today about the dog. He had previously testified that the dog was not great with strangers. This differs from his wife's testimony. She says, oh, no, the dog's fine with strangers, just not with other dogs. I mean, you can't hold one accountable for the other. Seems they have a difference of opinion. And the defense says, well, you said that the dog was barking because there were people downstairs. And is Chloe apt to bark when there's commotion? And the witness got defensive. He's saying, no, she doesn't usually bark. Oops. And I'll tell you why that's an oops. So no, she doesn't always bark at strangers or bark because there's people. She's not apt to bark at commotion because there's a whole number of areas that he can cover off by presenting the dog in that light. But there's a flip side, you see, and this is why it's so bad to lie. The flip side is this. If Chloe is not apt to bark when things are happening or there are people in the house, then if Chloe was barking that night, that means there was something bigger than usual going on that would cause a dog who doesn't normally bark to bark. So what was going on that caused the dog to bark if it wasn't simply that there were people in the house? And if he says now, oh, no, the dog didn't bark, well, then the question is going to be, well, hang on. You told your previous testimony was the dog did bark. Were you lying then or you're lying now? I'll let you decide which story here you want to believe, which scenario. Then it comes out he did allow Chloe to be downstairs and monitored. Well, Brian says, well, for a few minutes. So he's minimizing again, and he is once again impeached because his testimony, he was clear. He let the dog out in the backyard. He stood at the door. It only took a couple of minutes, and then he took her right back upstairs to the bedroom. Now, he'd allowed the dog to be downstairs with the people, but only for a few minutes. Chloe was rehomed in May of 2022. The witness says it's because of a dog fight, not the incident on January 29th. And the defense again brings up that 2 women were sent to the hospital as a result of the interaction with the dog. I mean, Brian Albert knows this, so it's not like he has to be told. It wasn't even a question. I think this is to drive this point home to the jury. And the defense suggested that you didn't get rid of Chloe until there were questions raised about the injuries on John O'Keefe's arm. So, of course, the prosecution's objecting. And, you know, this is interesting. I've been thinking about this. I'm a dog owner. Many of you have dogs. If I thought that rehoming would save my dog's life, I would suffer that. If they love the dog and fear that the dog will be harmed either by members of the public, because people see things on social media and do weird things, so, you know, the dog's at risk that way, or if the dog is accused of a bite that's severe, the dog may be at risk of being put down, depending on the jurisdiction. Would you give your dog away to save your dog's life? And the other argument about that is, well, if the dog's not there, they can't forensically match the dog with the arm injuries. Believe what you wish. Again, you can just believe that the dog had nothing to do with anything. I don't know. The defense brought out that John O'Keefe, because he'd never been in the Albert home before, would be a stranger to Chloe. They showed the graphic photo of the house again. They pointed out the 2 windows in the bedroom that overlooks the left side of the front lawn where John O'Keefe was. And by the way, because of the height, it's on the 2nd floor. If they had looked out that window at any point, they could have seen John there. The defense asked, you know, where's your bed in relation to the window? It's 5 feet from the window. The defense says, where were you at 2 a.m.? He says, in bed with his wife, with the dog in the room. The obvious question is, why was the dog not alerted to anything that's going on out there? He says at 6:03 a.m. he was sleeping. And the defense asked, did you take any sedatives? Did you wear a sleep apnea mask? Were you on any medications? Etc., etc. Did you wear an eye mask, earplugs? The idea is, why didn't you wake up? There were 6 emergency vehicles out front. And even though earlier testimony from first responders was they did not use their sirens, and testimony from Nicole was, well, they didn't see the lights because they had their blinds closed and their curtains drawn. I'm telling you, if that dog was in the room, the dog's gonna be waking them up. Even without sirens, there are people talking out there. There's movement, sounds of movement out there. And with the dog's hearing, the fire truck engines would alert the dog. The dog would be trying to get out the window. The dog would be alerting. There's no way, even a dog that's not trained to be a guard dog, there's no way that dog is not waking up and noticing that. Add to that earlier testimony was that the wind was loud and people, in order to communicate, had to yell at each other. So they're yelling over the wind, they're yelling over the sounds of the engines, and Karen Reed running around screaming. Tell me how that dog does not wake them up. Through this whole thing, I've been giving them the benefit of the doubt, thinking, you know, well, if they went to sleep at 2 o'clock in the morning, maybe they're just really tired. If they'd had a bit to drink, they might, you know, want to sleep longer. They had the blinds closed, all this. Trying to come up with every excuse in the book to be able to believe them. But the dog was not drinking it up till 2 a.m. and partying, and the dog is going to notice the engine sounds. The dog is going to be alerted to all that because they live on a quiet street. That's abnormal. My room is at the back of my house, and Watson will wake me up in the middle of the night for somebody on a bicycle across the front of the house, across the street, fiddling with bike pedals. I cannot believe that dog didn't wake them up. I'm sorry. It is unbelievable. Maybe you all have a different experience. So the dog sleeps with them, and all of a sudden, when the witness realizes that the dog didn't do anything with all this going on, Suddenly, he doesn't know where the dog is. The dog starts out in the bedroom with them. He's sleeping there, him and Nicole and the dog. The dog's on the mat. All of a sudden, Brian Albert doesn't know where the dog was. Maybe the dog was in the closet, because sometimes the dog sleeps in the closet. Well, I'm telling you right now, I don't care where that dog was in that house. That dog heard that noise. And unless the dog was locked somewhere else in the house away from them, which sounds like that is not the case, then there's no way the dog didn't alert. Then he said he didn't go outside even when he was awake. This is something the defense brought out. And on that point, well, by the time he claims he was awake, John O'Keefe had already been transported. The defense asked about the way to the basement. So the front door, to get to the basement, you pass the opening to the kitchen. The basement door is on the left. The defense was asking how many paces. And the witness was saying 8 to 10. And he seemed a little bit confused about the term paces, like what that means. And ultimately he said 6 to 8 feet. In the basement, there is a weight room in one room, and another room is empty, and there's plywood around in there. And in the basement, the floor is exposed, and it's a concrete floor. And so I want to say something here about injuries. So when you see an injury, to the front of the head, you might see a minor injury, but you see a big injury to the back of the head, which is what we see with John O'Keefe. We see it in DVs and CAs all the time. And usually, but not always, that means that either there was a strike to one side of the head and to either like a fall into a wall or a floor. So there's an impact to the back of the head. Sometimes people think, oh, you must have got hit twice, but it was an impact injury from something else. So if you get punched in the face, let's say, just being hypothetical, and you fall backwards from that onto a cement floor, you can have a head injury not from the punch to the front of your face, but from the impact to the back of your head. And you also see it when somebody forcibly slams somebody's head into the ground. So you'll see that front and back injury. That is consistent with John O'Keefe's injuries. You wouldn't expect the injuries there if he was hit by a SUV and fell onto a curb or concrete. You might see a wound to the back of the head, that impact wound from falling, but you wouldn't see the corresponding wound to the front because that's not, given his size, that's not the point of impact where he'd be hit by a vehicle. Just something to think about. We'll wait for all the expert witnesses and see what happens. So this is interesting. Concrete floor in that basement. The defense asked if you wanted to move a large or heavy item out of the basement without dragging it through the whole house, how would you do that? Well, there's a bulkhead door that goes out to the backyard. It comes out near the fence to the front of the yard, the same side of the front yard near the property line where John O'Keefe was found. And then they took a break. When they came back from break, the defense showed Brian Albert a photo of the bulkhead stairway. He showed how the door opens into the basement. And I bring that up only because I don't know if it's going to become important later. The bulkhead door at the top of those stairs opens straight up. Then he shows them a video. And the witness is saying, oh, that looks different. I don't know what that is. So when they continue the video, then he says he recognizes it. And he's saying, well, but the doors, somebody changed the doors look different. This witness is really working at minimizing or hedging as much as he can. And it isn't until the point at which he realizes he's not going to get away with something that he will relent. So I'm putting the video up on the screen. The video shows how you come up from the basement doors and It leads to the backyard, and the gate is right there. And where does that gate lead to? That property line. It opens to the front yard, and if you just walk straight, you end up at the flagpole. You end up in the area right where John O'Keefe was found. The witness agreed that 34 Fairview had been in the family for 2 generations. His parents built that house. It's been the Albert home for 50 years. In November 2022, the house was listed for sale. And the defense is asking, well, is that timing coincidence? And the witness says, no, he contacted a realtor in 2021 prior to this incident. In January 2022, the witness was still active on the police department. He was a sergeant detective. He investigated fugitives. And the defense was asking about his training and experience and said, you would be trained in how criminals try to thwart investigations, right? And this witness insisted that no, he was not trained in that. And the defense offered some things that you would think would be obvious, like, well, people cleaning up crime scenes, erasing cell phone data, that sort of thing. Nope, never received training in that. So that's wild to me. When the defense asks, you've had no training in how the techniques criminals use to cover their crimes, and Brian Albert goes back to his same pattern. And what he says is, I have not been to training on that. Kind of like I did not have sexual relations with that woman. He hedged about electronic data. The defense was asking, well, do you use electronic data to investigate? The witness played dumb. He hedged and hedged until he couldn't. The defense brings out that the witness had an iPhone for personal use. On September 23rd, 2022, a judge ordered that phone be preserved. And as the defense is trying to bring this out, the prosecution is objecting. Well, I don't know why you would object. It's a judge's order, but okay. I kind of know. I'm kidding. I know why. But anyway, I'll try and keep it short. So they end up at sidebar. And then the jury has to leave. And then the judge allows Brian Albert's counsel to be present in the room. So I'm watching this and thinking, man, if something happened to that iPhone subsequent to a judge's preservation order, then this witness is at risk and he's going to need his lawyer. Turns out that Brian Albert hired his own lawyer in 2022, but he's not sure when. And it was prior to some other testimony I gave. Well, he got a subpoena for another hearing that we're not hearing about here except in the periphery. So then there's another sidebar. In fall of 2022, Brian Albert was sent a notice on Commonwealth letterhead that said, do not alter or destroy this data, this phone data. And Brian Albert insists in his now patterned way, I do not remember getting that letter. So by the way he's answering, because now we have a baseline for him, right? By the way he's answering, we know he got the letter. The Commonwealth sent the letter, and he's using the I do not remember receiving it as a way to hedge and get away with whatever he wants to get away with in relation to that letter. You see, because he knows they can prove that they sent the letter. And they may even be able to prove that he received the letter, depending on whether it was served on him or just mailed or whatever. So he's covering his own butt. Wonder how often he answers this way in other areas of life. The defense asked, were you told in any other capacity not to delete or alter that cell phone data? And he said, yes, but that was after I upgraded my phone. And the defense asked, oh, well, when was that conversation? Well, I don't remember. And he doesn't remember exactly when he upgraded his phone either. So then he says he was told on a conference call. And the people on the conference call were Brian Higgins, the McCabe's, Steve Nelson, and my understanding is that he's from the prosecution's office, Mr. Lally. And Lally told Brian Albert essentially what the document said, like, don't destroy it. And since the witness has just testified, he got rid of the phone after an order from a judge to preserve. And now he's being told again by Lally not to destroy it, but he had destroyed it. Well, Brian Albert at that time did not tell Lally or anyone that I just upgraded the phone. He didn't bother to tell them. And when he was pressed on this, he said, well, I wasn't asked that, so I didn't tell him. Are you kidding me? If the roles were reversed, if Brian Albert, in his capacity as a police officer, was interviewing a witness or a suspect, and that witness or suspect withheld critical information, and then the witness turns around and says, well, you didn't ask me that, so I didn't tell you. How do you think he would respond to that? What do you think that he would think of that? So the defense is accusing him of destroying data when he was told by court order and by the prosecution's office not only not to destroy it, but he had to preserve it and make sure it wasn't manipulated or altered or anything. And you know what he says? I didn't destroy data. I did not have sexual relations with that woman. You know, he's saying that because he handed it over to whoever it was from the phone guy who's given him his new phone, and you trade in your old one. And the phone guy is the one that destroys the data. Now, that's not what he said, but that is the gist of it. So he can, in his own mind, justify, I didn't destroy data. And then he played dumb. And this went back and forth and back and forth. He played dumb as if he didn't know that the data would be destroyed, or he didn't know that the data would be gone. And getting anything out of him was like pulling teeth. And the defense asked him, did you seek advice from counsel about this? There's this preservation order. You destroyed the phone. Did you say, oh my gosh, and go seek assistance of counsel or advice from counsel? And again, his answer, I don't believe I did. So we can never know because lawyer-client communications are confidential. And again, in reference to another proceeding, there were questions about whether or not Brian Albert and Brian Higgins had a conversation prior to getting rid of phones, where Brian Albert said to Brian Higgins that he was going to get rid of his phone. And in another proceeding, Brian Albert said, well, I may have said that. But now he's denying it. And the defense again confronts him. Look, you know that when you hand over your phone like that, you know your data is destroyed. Because Brian Higgins and Brian Albert allegedly had this conversation where Brian Albert saying, well, I don't want anyone else to have my phone, like there's personal stuff on there. So if he's so worried about his personal data, would he not, if he's that uninformed about electronics, the guy who's hunting down fugitives knows nothing? Give me a break. Anyway, if he's that uninformed, yet that concerned about other people having his information, wouldn't he, as a police officer, as somebody who's cautious, wouldn't he want to check before he hands over that phone? So the defense is saying, you know that data gets destroyed. And his answer, I don't know that for a fact. They go back and forth and back and forth. And finally, the defense said, okay, where's your phone? Where is it? Because the defense had asked for it. Where's your phone? He says, it was upgraded. The witness testified. He upgraded that phone and got rid of that phone on September 22nd, one day before the court order that required him to preserve that. How convenient. Then the defense was asking, when did you make this decision to get rid of this phone? The witness says, well, September 4th was his birthday, and his phone was broken, so he planned to get a new phone. September 4th and September 22nd, that's like 18 days. Do you believe him? And of course, the prosecution is objecting to previous testimony coming in even. And the witness says, well, it was just all coincidence. And they went back and forth about conversations between Brian Albert and Brian Higgins getting rid of both of their phones. And it's quicker to play the clip than it is for me to explain it to you, but listen for his pattern of hedging and the way he splits hairs and plays semantics games. So here it is.
Did you and Brian Higgins agree with each other that you were both going to get rid of your phones?
Objection.
I'll allow that.
No.
You testified at the other hearing in June of 2022, quote, I don't recall saying that I was going to get rid of my personal phone to Brian Higgins. I may have said that. You know, there's personal stuff on my personal phone. I don't recall saying that to him, but I don't know. We had multiple conversations about things, end quote. You remember testifying to that?
Yes.
So you're not ruling out the fact that you may have told Brian Higgins that you intended to get rid of your phone, correct?
No.
You're not ruling out the fact that Brian Higgins may have told you that he intended to get rid of his phone?
No, I don't remember him saying that to me.
Your testimony was, quote, I know there were conversations about the phones. I just can't say if he was going to get rid of his phone or not, end quote. You testified to that, didn't you?
Yeah, I have no idea what he was going to do.
I'm asking, are those your words? Did you testify to that under oath?
Yes, although I don't know the context of the time that they were asking that question.
June of 2020.
No, not the date of the hearing, but when they were asking if and when that conversation took place.
Does it really matter when it took place?
I think so, yes.
Well, you talked to Brian Higgins about getting rid of your phones. When do you think you had that conversation?
I don't think I talked to Brian Higgins about getting rid of my phones.
Well, you just said you can't rule out the fact that you had conversations with Brian Higgins about your phones and possibly getting rid of your phones. Right?
No, I don't think that's what I said.
You two discussed the fact that you both wanted to get rid of your phones.
I don't remember having that conversation with Brian Higgins at all.
Your testimony was, quote, I know there were conversations about the phones, sir. Correct?
Correct that that's what you're reading?
So if you're having conversations with Brian Higgins about the phones, what the heck were you talking about?
I don't know the timing of when they asked when those conversations were.
Mr. Albert,
So
I'm leaving it open to you. I don't care when it was. I'm asking you, have you ever had a conversation with Brian Higgins about your phones, respectively?
we may have, I can't remember that conversation specifically.
Then why in June of 2023 did you testify, I know there were conversations about the phones with Brian Higgins, end quote?
I'm not sure of the context of that.
So now you just can't remember.
No, I don't think I could remember during that testimony either. I think if you read the whole thing, I think I said I'm not sure, I don't remember.
Your quote was, I know there were conversations about the phones. I just can't say if he said he was going to get rid of his phone or not, end quote.
Right.
Does that help refresh your recollection?
Yes.
So now as you sit here and you answer my question, did you and Brian Higgins have a conversation about your phones?
I don't remember having that conversation with Brian Higgins.
All right, let's shift gears.
The defense asks the witness, are you aware that Brian Higgins got rid of his phone? And he tries to give a narrative. And the defense stops him and says, yes or no, yes or no. And the prosecution objects. And the judge says, well, do you know the answer? Can you answer yes or no? And the answer is yes. He knew Brian Higgins got rid of his phone. The defense asks if Trooper Proctor was in his home on January 29th. The witness says he doesn't remember. And then he says, well, maybe for my wife. But we know, the jury knows, and the defense reminded them, that wasn't actually until February. The defense pointed out and said to the witness, who is a police officer, the longer the wait to investigate, the more chance that evidence will disappear, yeah? Did forensics ever enter your home to look for anything? No. Did any investigator search your house? No. And still, to this day, that house has never been searched. They got into Brian Albert's training in fighting, and the defense brought up his Marine training and asked if he was trained in hand-to-hand combat. And the witness paused. He does not want to answer this question. But you see, this is one of those ones he's not going to get away with a blatant lie. I mean, does anyone believe that a U.S. Marine is not trained in hand-to-hand combat? So he has to say, yes, he was. But he makes it clear he was not trained in fighting techniques or hand-to-hand combat through the police department. Okay, so he's trying to minimize his fighting skills, but still, even with just the U.S. military training, it means he had more training in combat than John O'Keefe. If the police there don't train that, and they train defensive stuff, right? Or restraint stuff. So if the police don't offer that training, that means that Brian Albert has an edge on someone like John O'Keefe. And here's the thing, he's trying to minimize his own skill level or the perception of his skill level. But what he has done by answering in this manner is to show that John O'Keefe actually has less training in physical fighting than Brian Albert does, which is exactly the thing that I think Brian Albert was trying to avoid. The defense brought up how this witness was a trained boxer, and the prosecution objects. And so he agrees that he's had some training. And again, it's like pulling teeth to get this out of him. The defense says, well, your boxing skills were even featured on a TV show. And the witness says, no, not featured. See again? He's playing with the words. Very specific. So this tells me he was on a TV show boxing. Comes out that, yeah, he was on TV in a boxing ring. The defense shows the video at the waterfall of the two Brians in a boxing stance. And it turns out that this video clip is the video clip that Lally showed to Brian Albert. And the witness says Lally didn't ask any questions about this video, didn't talk about it. Okay, this is unbelievable. The prosecution isn't just like having tea with witnesses and not talking about anything. He's not gonna get access to the exhibit and get somebody to pull out the file and go through video with the witness because he has no questions and nobody has anything to say about it. Come on, that is unbelievable. And pretty soon we're going to have the prosecution on the stand defending themselves. The witness agrees, finally, that him and Brian Higgins were in a fighting stance. And the defense asks, were you sharing techniques? No. And throughout this whole discussion about what they were doing at the waterfall, this play fighting, the witness keeps reframing it as being silly. I heard Sarah Boone's voice in my head saying we were being silly. The defense asks, okay, describe what you're doing. Being silly. He knows that is not what the defense is asking for. And he keeps asking him, describe to me physically, what are you doing? At one point, there's video of Brian Higgins putting a knee up to Brian Albert's abdomen. Again, play fighting. And John O'Keefe had abdominal distension that could have been caused by trauma. Just throwing that out there. I mean, I'm not a medical expert. I don't know. The witness insists they are not practicing fighting techniques. The defense asks, well, you're being pretty friendly with each other. The witness says yes. The defense asked, well, was anyone else doing that? play fighting, or as you call it, fooling around? I mean, he's gotta know the answer's no, right? But his answer is, I don't know what everybody else was doing. This guy is so stubborn. He says, early morning of January 29th, everyone was gone by 1:45 a.m. The defense asked him, what did you do to get ready for bed? And the witness says, watched TV. I was kind of expecting that, I went and brushed my teeth or whatever. No, watch TV. The defense asked, and he keep the phone on the nightstand? No, he keeps the phone with him. Not on the nightstand, not charging. Why? I mean, he's talking about keeping the phone in the bed with him. And remember, I haven't heard anything about this case until now. So this was getting my attention. Like, that's weird, man. So he says that night he remembers the phone was on the bed, but he doesn't remember so many other things that were important. They got into, well, you always keep your phone in your bed. He says, yes. Well, when do you charge it? Well, sometimes if it needs to be charged, then I charge it and then it's not in the bed. His memory is so bad on other things, but he can remember how much of a charge he had on his phone that night and whether it was in the bed or not. Tell me what you think that he would think if a suspect tried to run that by him. And a couple of minutes later, he says, well, I don't remember if my phone needed charging. Well, then you can't remember whether or not you had it in the bed. This is all BS. The defense asked, did you make any phone calls between 1:45 a.m. and 6 a.m.? And the witness says, I inadvertently called Brian Higgins. He says he doesn't recall the time. And according to cell records, it was 2:32 a.m. He says he didn't talk to him. Well, wait a minute. If he knows he inadvertently called, but he didn't talk to him, like how can he recall or not recall anything about time if he didn't even know about the call? Turns out he had given previous testimony about this phone call. He said he was hanging out with his wife at 2:22 a.m. and must have butt dialed. Well, also, his earlier testimony was that when everybody left, they went to sleep. So he's also not sleeping. In yet different testimony, he said that he was in an intimate situation with his wife, and that's when the butt dial occurred at 2:22 a.m. If this was the defendant telling this story or this series of story, any one of these stories, would anybody believe it? The defense asked, do you recall all your phone calls? He says no. So the defense shows him a phone log. The witness says this isn't all the calls. Crikey. If it's not all the calls, well, you know why the defense doesn't have all your calls? 'Cause you destroyed evidence! January 29th at 2:22 a.m., there was a phone call from Brian Albert to Brian Higgins for 1 second. Well, you tell me this. If you butt dial and you're not even aware that you did that, how quickly are you going to notice and then hang up? Okay, so you notice you butt dial and go, oops, and you hang it up. So you'd have to know you did it in order to hang up. But he was being intimate with his wife. Like, how closely is he paying attention to his phone? Like, there are jokes in here, man. 17 seconds later, Brian Higgins phones Brian Albert, and that call is 22 seconds long. And I'm going to mention something here about this phone log. So the defense shows Brian Albert the phone log. And while I was watching that, I'm thinking, why is he doing that? Let him lie and then impeach him with the document, right? And that would be great. Except in this case, this defense is running a risk if he goes that route, which would be sort of the traditional route. Well, in this case, the defense runs the risk of having the judge cut him off. He has tried to go down that road where he gives the witness enough rope, so to speak, and the judge interrupts and says, let's move this along. Or next question. This second call, the call from Brian Higgins to Brian Albert, lasted 22 seconds, but Brian Albert says he did not answer that phone call. What? Did he get a voicemail maybe? So the defense asks, did you tell law enforcement that you got a missed call from Brian Higgins, after 2 a.m? The answer is no. Remember, we are talking about an experienced police officer. Another police officer is found dead on his front lawn. This is going to be a big investigation, or it ought to be. And this witness doesn't disclose this? Okay. So the defense goes through, well, you must have saw you got a missed call. And he says no. And he also says he did not get any voicemail from Brian Higgins. So he did answer the call. If it didn't go to voicemail, it's not lasting 22 seconds unless somebody picked up the phone. They're going on about this phone because this witness is lying. At bedtime, you close and lock your phone, yeah? Yes. Or if you don't use it for a while, it locks itself. He has a 4-digit passcode. In order to open the phone, you need to either punch in the 4-digit passcode or you can use facial recognition. You want to make a call, you got to either put your face to the phone, you have to open the phone, and then you have to tap on the phone app, and then you have to tap on a category like friends, recents, contacts, right? Then you have to tap which contact you would like to phone. And in order to hang up, you have to tap a button. Makes butt dialing pretty hard. And then the witness says, well, I could have been looking through my phone so it was unlocked. All right. So if you're looking through your phone so recently that it was still hadn't locked itself, but you were having intimate relations with your wife, like how is that? The judge ends up calling a sidebar. When they come back from sidebar, then the witness now says he doesn't know if the phone was unlocked and he made a call. And then the witness claims he didn't even know about those calls. And the defense asks him, did you answer a call? And the answer, not that I know of. Are you flippin' kidding me? So the defense asks, and this was gold. The defense asks, well, who was in the room with you? Nicole. It was just Nicole and Brian. And the defense says, and Chloe, the dog. And the witness says, well, yes, but Chloe's not a human. No, Chloe can't make calls. But you know how smart this was? Because you know what the defense just did here? The defense just got this witness to confirm that Chloe was in the bedroom. Because remember earlier he was hedging, well, I don't know, maybe she could be anywhere. Maybe she wasn't on her mat. Maybe she was in the closet. Well, guess what? He just confirmed that dog was in the room. And he didn't know it because he is so interested in covering his butt and being defensive in that moment about that argument. That is where his focus is. He admitted the dog was in the room. Okay. They go back over previous testimony, and he says, I don't recall talking to Brian Higgins. Did you talk to Brian Higgins about that 2:22 a.m. call? And Brian Albert says, yes, I told him I may have inadvertently called him. I might have butt dialed him. He's saying he said this to Brian Higgins on January 29th, so the next day. Well, hold on. If he's not aware of any calls, didn't answer any calls, didn't see any missed calls on his phone log, didn't get a voicemail, he's just not aware of any of this, must have been a butt dial, but he's not aware of it. So how does he tell him about it? The next day, 7:20 a.m., Brian Albert calls Brian Higgins. And out of all the people that Brian Albert could have called, because by this time, Jen McCabe had burst into the room and told them John is dead. All this, right? This is all going on. Of all people, he decides to call Brian Higgins, not a brother, a close friend, Brian Higgins, who he's trying to say, well, they're not really like super close, but that's who he calls. Now, why is that? He says he told Brian Higgins what happened, and that call lasted 1 minute and 56 seconds. So he felt it important to tell Brian Higgins what happened. Well, why is that? If Brian Higgins had nothing to do with anything, why? And if Brian Higgins did have something to do with it, just the fact that he was there and is a witness, then Brian Albert The experienced detective knows he shouldn't be calling him to give him a heads up. They went through a series of phone calls.
Mr. Albert, I have a couple of more questions about the phones, or the phone usage that morning and in the day, throughout the day. You called Brian Higgins at 7:20 a.m. for 1 minute and 56 seconds, correct?
Yes.
Brian Higgins called you at 7:30 for 5 minutes and 47 seconds.
Yes.
You called Brian Higgins at 7:57 a.m. Spoke for 12 minutes and 33 seconds.
Yes.
You then called your brother, Kevin Albert, at 9:40 a.m. and spoke for 1 minute and 5 seconds.
Yes.
Chief Berkowitz called you at 9:50 a.m. and left a voicemail. Is that right?
He didn't leave me a voicemail, but I think he called me.
You called Chief Berkowitz back at 9:54, 4 minutes later, and spoke for 4 minutes and 40 seconds, right?
Yes.
You called Jim McCabe at 11:30 a.m. Is that right?
Yes.
And Jim McCabe called you back at 12:20 p.m. You spoke for 7 minutes and 52 seconds.
Yes.
You called Kevin Albert again at 2:01 in the afternoon and spoke for 8 minutes.
Yes.
You called Kevin Albert at 6:45. I'm sorry. You called Brian Higgins at 3:24 p.m. and spoke for 6 minutes and 5 seconds. Is that right? And if it refreshes your recollection, there's a second page, second log. You'll turn your attention to the 3:24 p.m. time frame.
I see it. Yes.
And there's a second call. You call Brian Higgins at 6:12 p.m. and speak for 1 minute and 7 seconds, right?
Yes.
And then the third one on that page, you called Brian Higgins at 6:35 p.m. and spoke for 10 minutes and 12 seconds, correct?
Yes.
Turning back to your call logs, you called Kevin Albert at 6:45 on the next on that same day. Spoke for about 16 minutes.
Yes.
Then on the next day, January 30th, you called Chief Berkowitz and spoke for 1 minute and 6 seconds.
Yes.
And the following day, you spoke with Jim McCabe, who called you at 8:04 p.m., correct?
Yes.
And finally, Chief Berkowitz called you at 1:48 p.m. on February 1st, right?
Yes.
3 days later, you spoke again to Brian Higgins at 8:48 a.m. Is that right?
Yes.
The subject of these calls, Mr. Albert, were all about the fact that John O'Keefe was found dying on your yard, on your lawn, on January 29th, 2022. Isn't that right?
I don't know the subject of all these calls, no.
He's calling the chief? Wow. But there are more calls? This is laughable. Does he want the defense to introduce calls that aren't relevant? Or is it the fact that there are more calls, but because of Brian Albert's actions, those have been destroyed? I don't know. The judge interrupted the cross-examination yet again and sent the jury to lunch and called a sidebar. In the afternoon, the cross continued. September 22nd, 2022, the phone was upgraded. Also, September 22nd, 2022, there were proceedings against Karen Reed that were widely televised on that day. And they asked Brian Albert, did you watch those proceedings? And he insists he did not. Then they got into a statement that Brian Albert made in June of 2023 at the other grand jury. And Brian Albert had said, it's only possible that it was me who answered the phone. So when I'm hearing this, I'm thinking it's a weird word order here. Only possible rather than possible that it was only me. You could argue that. But the defense did a good job here because they clarified it. Because they read the question as well as the answer. And the question was, if it wasn't your wife, it wasn't the dog, who left is possible to answer the phone? And the answer was himself. The defense asked, were you getting your story straight? No, absolutely not. Well, of course he's going to say that. On redirect, the prosecution talked about the time that Brian Higgins, Brian Albert were at the hillside and Karen Reed took that picture of them with John O'Keefe. And the prosecution said, well, you weren't there with them, right? Like you didn't go there with them. And the witness says, right, that's right. Except earlier, he'd slipped up. He had said she was just somebody sitting across the table. They sat at the same flippin' table. Don't tell me that they weren't there together. Maybe they didn't arrive together. Maybe they didn't plan it, but they ended up together. And he, whether he realizes it or not, made it clear by making reference to that she was across the table. The prosecution asked, why were you going to Jen McCabe's on the day she was being interviewed? The witness says, well, because she was distraught about everything that happened and he wanted to comfort her. Yeah, but in earlier testimony, he did admit, yeah, I also knew that a trooper was coming. He claims he didn't go into the basement that night. He was asked on redirect. So remember, this is the prosecution trying to rehabilitate these things. The prosecution asked, did Brian Higgins go into the basement at any point? And the witness said, not that I know of. I did not have sexual relations with that woman. This is his pattern. This is his tell. And you know what this tells me? This tells me if he feels that he needs to throw Brian Higgins under the bus at some point, if it comes to that, he'll do it. Or if it comes out somehow, he's trying to create plausible deniability. If some other witness slips up and says, yeah, I saw them come or go from the basement. Maybe some neighbor saw them coming out of that bulkhead. Who knows? Maybe there's a ring camera somewhere. He doesn't know. And he knows as a police officer that very often there are all kinds of things that investigators find that the offender never dreamed anybody would find. He knows that. This is plausible deniability, not that I know of. So if he's ever confronted, he'd say, but I didn't know. The prosecution was saying, well, you said, your dog didn't like strangers. And he's saying, well, what I mean is she's not affectionate with strangers. Not being good with strangers and not being affectionate with strangers are two different things. The witness said that the dog had never been aggressive except for that one time that they brought up in court. Well, here's the thing. The aggressiveness from the dog was brought up in Nicole's testimony, and the fact that it was more than once that there was aggression with the dog. But if Brian Albert wasn't there listening to that testimony, and he couldn't be, and if Nicole didn't mention that little detail to him, he wouldn't know that. So he's just going with what he knows that they can prove, and that's the one time. And he says, dog's never been aggressive except for the one time. So we know he is lying. And I'm not saying mistaken. I'm saying lying. Because he could not know that there was more than one incident. The prosecution again brought up the funeral in New York. The prosecution did point out or bring out that they only got a few hours of sleep. The prosecution brought out that when Brian Albert looked out the window, John O'Keefe was not out there. And then he said this. He said, he went down the stairs and his wife said, where's John? Oops. Earlier, Brian Albert had blurted out on the stand that Jen burst into the room and said John is dead before he was stopped. And he'd also testified, and so did Nicole, that Jen said the police wanted to speak to him and that's why they went downstairs. Brian Albert is just trying to play now on the emotion of all this. And whether or not you're a friend of Brian's or Chris's depends on whether it suits them in the moment to call you a friend or not. That's how it seems to me. The prosecution tried to sort of rehabilitate this whole thing about that bulkhead door because that was some. He says the bulkhead door is right under the bay windows in the kitchen, right? To imply that, well, people would see you if you came out there because everybody was hanging out in the kitchen. But here's the thing, and there was testimony about this earlier too, about the visibility and the light. If the light is on in the kitchen and it's dark outside in that backyard, there's no street lights back there or anything, well, you could be almost right up at that window and nobody'd see you. You could do that. And then the prosecution brings out the fact, well, would the door make a noise? And the witness says, oh yeah, it's an old rusty door. Yeah, it would creak. Hang on a second. They're talking about how the wind was howling. There were people in the house. They had music playing. And the fact that they had music playing seemed important, right? They want to use all of those things, all the ambient noise, to say that they could not hear what was going on outside. They could not hear Karen Reed screaming. They couldn't hear multiple first responders yelling at each other. They couldn't hear the engines of the fire trucks and the vehicles out there. They couldn't hear the noise from the police radios. They couldn't hear anything. But now, when that inability to hear is inconvenient, it doesn't suit them, now everybody should forget about all of that, how they had the music playing and all that. Forget it. And believe that they would hear a door creak outside. Do they think that everybody is that stupid? The prosecution brings out the fact that there are other gates in the yard that lead to other places, including like down to the train tracks. Yeah, okay, so what? That's a red herring. It doesn't mean that the other gate that led to the side of the house right to the area where John O'Keefe was found, it doesn't mean that that gate doesn't exist because there's another gate. Prosecution brought out the fact that the judge on September 23rd denied the defense's request to have Brian Albert's physical phone. The judge couldn't give it to them. How does the judge give them the physical phone or track down the physical phone when Brian Albert got rid of it? The prosecution asked, well, when you did your phone upgrade, like there's a cloud backup, right? But the bottom line is the defense wasn't able to get what they needed to get. The prosecution brought up that Brian Albert hadn't done boxing for like 20 years. Yeah, okay. I know somebody who trains American military, and the way they do the training is so that you don't forget. See, there's something called stress inoculation. Because when you come under fire or when you're in a life or death situation, if you just took some lessons, you're not remembering any of that. So they drill it into you in a very specific way so that you have like this muscle memory. It's almost automatic. You don't think about it. It kicks in. And you talk to old vets who haven't been in service for a while, who have ended up in a situation, and they'll tell you that training just shows up. It kicks in. You don't forget that stuff. Oh, you might forget one specific thing or so, but for the most part, especially when it comes to stuff like hand-to-hand combat or anything where you need to save your life or somebody else's, your training kicks in. And military training is designed that way. So I don't care that he didn't box for 20 years. There's some things you don't forget. Then the prosecution brought up something which, I thought was hilarious in my, dark humor sort of way. The prosecution said, well, your phone reception in your house is bad. Sometimes you refer to certain places in the house as a dead zone, yeah? And Brian Albert says, yeah, that's right. Well, hold on a second. If that's the excuse, if the phone reception being bad is the excuse for why maybe he didn't notice that Brian Higgins called him, even though that call picked up for a number of seconds, if that's the excuse, yet the reason he butt dialed Brian Higgins to begin with is because he kept his phone in his bed because he needed that phone really close to him. Not a couple of feet away, like right in the bed with him, in case one of his kids called. Well, if that room is a dead zone where he can't get the call from Brian Higgins, why does he have the phone in that room at all if he's so worried about his kids? Why wouldn't you put it somewhere in the house where there's better reception and turn it way up, or any number of other solutions? Come on. Prosecution referred to the call log that the defense presented to the witness. And now, because this witness is more comfortable, he framed that call log as selective. Well, buddy, what would happen if the defense took your entire call log of everybody you called, you who are so worried about your data, what would happen? There would be objections because you'd all be saying it's not relevant. You shouldn't have this. You're invading my privacy. You shouldn't have this. They shouldn't be presenting into evidence, into the record, call logs with irrelevant personal phone calls there. That's if they have them. And I don't know the answer to that because, the phone was destroyed. This is unbelievable. The witness claimed he was unaware of the accused or the victim being anywhere around the house. The defense asked, did you speak to Mr. Lally about the cell phone reception? And this is really interesting because if he did, Lally obviously did not disclose this to the defense. So it's going to be really important when the prosecution learned that. So the witness said he did. He did disclose that to Lally. The witness agreed that he did speak to Lally over lunch. And when he was asked, well, what were you talking about? And the witness says, well, just, how much time I had left on the stand. And when he was pressed, he said, well, and he mentioned one question he was going to ask. And then the witness said, some questions. So they had a conversation. And that was it for the cross-examination of Brian Albert. So that's all I've got for you for the moment. Trust your gut. I'll see you in the comments.